Well, good morning. I was going to say, as we usually start the day with my lords, ladies and gentlemen, but I'm going to say good morning, my friends, because we have been together now for a number of days. We've enjoyed each other's company and we've had an excellent conference. So you're very welcome to the closing ceremony of the 19th Commonwealth Law Conference. We will a little later be hearing from, amongst others, Commonwealth Lawyers Association outgoing President Mark Stevens after our final keynote address this morning from the Honourable Michael Kirby of Australia. That will be followed by the presentation of the Moot Competition Prizes and the presentation of the LexisNexis Rule of Law Award. Thereafter, we will have the flag exchange, and the conference will be closed by President of the local hosting organisation for the conference, the Law Society of Scotland. So, to get matters started and to introduce His Honour Michael Kirby, I call upon Mark Stevens, President of the Commonwealth Lawyers Association.
Yes, friends, a very apposite exhortation, and I repeat it to you, friends. I have the distinct honour of introducing to you this morning, for those of you that don't know him, the ebullient and irrepressible member of the judiciary, His Honour Michael Kirby. Michael was very many years a judge of the highest court of Australia, the High Court of Australia, but more than that, he's an eminent person, so dubbed by the UN and the Commonwealth. And I recall first meeting Michael many years ago in Boston when the Australian government had the wisdom, the Australian Court Service had the wisdom to send him to teach me how to observe trials around the world. And that sort of skill and that understanding of human rights and basic issues relating to the rule of law, the sort of things that are captured in the Commonwealth Charter of Human Rights. Those are the sorts of things that we look out for when we're doing trial observations. And I've done trial observations from the newest Commonwealth country, Rwanda, the Gacaca trial, through to more traditional trials, both in the civil and the common law tradition. But it was thanks to Michael who really inspired me in relation to my understanding of human rights and the rule of law. And it's with that very personal introduction, for which I really don't make any excuse at all, because many of us come into the profession because we want to see justice done, because we believe in the rule of law and access to justice. We believe in the enforcement of rights. And with that, and without any further ado, I give you Michael Kirby.
Thank you very much, Mark, and good afternoon, everybody. I'm very proud to have this obligation of seeking to say something that is worthy of this conference. But when we go back to our own countries, I suspect it won't be the words of people like me that we remember. We will remember Carl, Victoria and Lucy last night with their magnificent singing, and they took me in at the beginning, being a very naive judge, of course. I believed anything I was ever told, and I thought this man had just come out of the kitchen and that Victoria was about to go off and get married, and she was giving us her karaoke act. And it was just a wonderful evening. And then the pipers at the end. I don't think it'll be easy for any Commonwealth Law Conference in the future to organise a dinner with such tremendous verve and energy as we saw last night. Yeah. So let's give a big round of applause for them. There's just something very special about the Scots. Now, if you set out on the journey to this place from Auckland, and if you cast your eye as you went to the check-in up to the ceiling, there is a wall there which contains an extract from a poem by Alfred Lord Tennyson called Locksley Hall. It was an early poem of Tennyson, and he wrote it in 1842. So that was many years before he became the Poet Laureate of Queen Victoria. And the poem was strangely prophetic. And he said, "I am thinking of a future time when there will be great ships of the air that will unload bales of produce in the far reaches of the world." And amazing that this could have been written in 1842-43 by Tennyson. And the poem finishes up with the following passage, which is a sort of dream of this poet writing in his youth in 1842 in England. He's dreaming of a world that will come. And this is what he said: "Till the war drum throbbed no longer and the battle flags were furled, in the Parliament of man, the federation of the world, where the common sense of most shall hold a fretful realm in awe, and the kindly earth shall slumber, lapped in universal law." Lapped in universal law, the dream of 1842, long before the League of Nations came along in 1919, long before the United Nations was formed with its charter and with the Universal Declaration of Human Rights in 1945 and 1948 respectively. People were dreaming of a world of universal law. And the Commonwealth is part of that dream, and it's why we have come here from so many different countries. We share a language, which is a great gift, because it is, if any language is the universal language, it happens to be the English language. We share in the law the precedents and the way of doing things, and the feeling of justice and fairness that permeate our legal system. We also share many statutes and many laws that have been handed down to us, and we share the principles of the Magna Carta. I'm wearing today, proudly, my Magna Carta tie, because this is a symbol that we have inherited. It's a good symbol. To no man shall I sell, to no man shall I deny justice. And therefore we share many of these things, and yet those things would remain if we didn't have the Commonwealth. We could still meet occasionally, and we would certainly in our courts, in most cases, still be using the English language in the higher courts, and we would still be looking occasionally at the law reports of the Commonwealth and other books that contain the principles of the law which we share in common. The Privy Council has long since packed its bag for most of us, and there is no obligation for us to follow, but we find it helpful. And the fact that we do things in strange ways, fair ways as we think it. One of the reasons I believe that my recent work for the United Nations on North Korea was successful was because we went about it in my inquiry, in the inquiry of the Commission of the Council on Human Rights, in a common law way. We held public hearings. We had witnesses. We listened to the witnesses. I led them in chief. We had no counsel assisting. I didn't put words in their mouths. We took a film of their testimony. We had a transcript of it. It is online. The whole world can have access to it, except in North Korea, to see the witnesses. These are very much the ways of the common law. It's just the funny way we do things, with great emphasis upon transparency, upon argument, upon reason, And this is something that would survive even if the Commonwealth of Nations were no more. We get to this point in the long story of the Commonwealth of Nations, emerging out of empire through 4 great shocks that the Commonwealth and its countries suffered. The first shock was the American Revolution of 1776. And strange to say, Australia is a very direct product of the American Revolution. It was the fact that the American revolutionaries insisted on having at their home what they thought were the fundamental rights of Magna Carta and of British subjects living in the American settlements. They, in their Declaration of Independence, denounced King George for denying them the rights, denying them the principle of no taxation without representation, a pretty fundamental principle. And so the first shock was the American Revolution, and because the convicts on the ships in the Thames, and no doubt here on the Clyde, could no longer be sent across the Atlantic to America, they had to find somewhere to send them. And so somebody remembered Captain Cook. He went out there, he found this big, apparently empty land, and we will send them out to Australia. And so they did, and that's how my country, Australia, in its modern manifestation, began. But a second shock came along as a result of the war which was raging exactly 100 years ago as we meet. You know, in Australia and New Zealand, a very solemn day is Anzac Day. It's the day when our 2 countries, Australia and New Zealand, are said to have come of age, because in huge numbers for our tiny populations, I think Australia at that time was 6 million people, and every little village across the continent of Australia and in New Zealand, there are war memorials with the names of many young people who died at Anzac Cove, the Australia-New Zealand Army Corps. And exactly at this moment, 100 years ago, they were on the ships in the Dardanelles, outside Suvla Bay, waiting to go as they would do on the 25th of April of 1915. But because of the huge sacrifices which the Dominions, Canada, Australia, New Zealand, South Africa and India suffered in the First World War, they all began to demand a greater degree of self-government. And so that degree of self-government finally manifested itself with the participation of the Irish Republic, by then of a high degree of independence in Ireland. That manifested itself in 1926 in the Balfour Declaration, and that's named after a former Prime Minister of Britain. And the Balfour Declaration said, "We are bound together by allegiance to the Crown, but no longer may the Imperial Parliament make any laws for us. We are not subject to them in any particular, and they can only make laws for us by our request and with our consent." The second shock. And then the third shock came in 1949. And the Prime Minister's group was now enhanced by the participation of the Prime Minister of India and of Pakistan. And India made it very clear that they intended to become a republic, so the glue of allegiance to the British Crown would no longer work. And those 2 great men, Clement Attlee, the Labour Prime Minister of the United Kingdom, and Jawaharlal Nehru, the first Independence Prime Minister of India, decided that there was a solution to this, that there was enough in our association to try to keep something continuing, and so the admission of countries, though they were republics, would be accepted so long as it was acceptable to all the members. And so the second and third shocks were overcome. And we were doing pretty well after the third shock. In 1952, when the king died, it was Nehru who said, well, we will of course recognise Queen Elizabeth II as the head of the Commonwealth. And it was by Nehru's decision that that step was taken. And the Queen became the titular head of the Commonwealth, with no power, no obligation of allegiance, but faithful has been her duty as the head of the Commonwealth. And when South Africa, with its apartheid regime, created the challenge to the Commonwealth, South Africa was told when they became a republic, well, we, I'm afraid, will not accept you. And South Africa turned up but went away empty-handed. The Commonwealth stood up for the principle of non-racism. And it did that again after the 1971 Singapore meeting of CHOGM and the Singapore Declaration. It did it once again with Rhodesia, when Rhodesia sought, after its travails, to have a land built on racism. That is not acceptable to the Commonwealth. And Rhodesia was sent packing. But then things began a little to unravel. Coups took place in Nigeria, in Pakistan, and in Fiji, but the Commonwealth, sometimes belatedly, stood up against the coups and said, you cannot be a member of this body if you are the product of overthrowing a democratic system. CHOGM was getting big, and the result of the accession of many independence countries, most of them republics, was that the intimacy of the small group of 10 or 7 prime ministers was replaced by a much bigger organisation. A very precious feature of the CHOGM meeting had been that only the prime ministers, or then later the presidents and prime ministers, would be admitted to the meeting. The heads of government had to be there. CHOGM is the Commonwealth Heads of Government meeting. And they had a retreat, and this was different from every other international meeting. They would go off just themselves, plus the Secretary-General, and no officials were allowed in, and they would talk with each other. That didn't happen at the G20, didn't happen at the G7, it didn't happen in many other international groupings, just the leaders. And then that began to break it down. Some heads of government were not turning up. Some would send a minister, maybe not even the second minister. And then they wanted to have their officials coming in to the retreat. And the retreat became a big bureaucratic type meeting. The intimacy was being lost. And human rights values, which had been so manifest in the stance taken on apartheid South Africa and racist Rhodesia, began to be questioned. Things were happening where human rights were not being respected. And that led to deep questioning, does the Commonwealth have a future? And that questioning came to the boil in Trinidad, in Port of Spain, in 2009. And the result of the meeting in Trinidad was a decision of the heads of government to establish a so-called eminent persons group to look into the future of the Commonwealth. There'd been one eminent persons group before, and it was in relation to South Africa and Rhodesia. And one of the former Prime Ministers of Australia, Malcolm Fraser, who died only last month, he was a member of that eminent persons group, a very fine and decent man. But the Eminent Persons Group of 2009 was to have a wider, intercontinental, Commonwealth-wide mission. And its mission was to examine what could be done to make the Commonwealth fit for purpose in the 21st century. And what do we have to do to make sure that the Commonwealth doesn't just fade away? There was no risk that the Commonwealth would disappear by attack from without, but there was a real risk that it would fade away through indifference and through the non-participation with the same energy and the same dedication as Nehru, Kenyatta, Lee Kuan Yew and others had brought to the early meetings of the Commonwealth in the 1960s. And so the Eminent Persons Group of 2010-11 was established. And I was appointed to that group. The chair of the group was a very distinguished Malaysian politician, Tun Abdullah Badawi. Badawi had become the Prime Minister of Malaysia after Dr. Mahathir. That wasn't an easy step to take, to follow Dr. Mahathir, who was a very strong, creative, determined politician, but Badawi took the post, and he was honest and honourable, and he was appointed to be our chair. There were 9 others, a mixture of men and women, of young and old. We had one young man, Sami Kavumi from Uganda. We had people who were Islamic, Christian, and of no faith. We had people who were professionals, lawyers, and whose experience had been in international organisations and different activities. And we got together in 2010, and this group was set to work on a mandate which was very large and very challenging. How can we make the Commonwealth survive? And how can we offer institutional and other steps that could be adopted and that would ensure its survival into the future? The report of the Eminent Persons Group was produced efficiently. We had meetings in Marlborough House, the former Royal Palace that the Queen had made available to the Commonwealth Secretariat in London. In our meetings, there were only the members of the EPG, the Eminent Persons Group, present, plus the Secretary-General, and occasionally the Secretary-General would bring in colleagues to help on particular matters. The report was written by our consent by Sir Ronald Sanders. Sir Ronald Sanders from Guyana is a former diplomat and an old Commonwealth hand with a lot of experience in the Commonwealth. As it happens, he is the son-in-law of Sonny Rumphal, who had been the Caribbean Secretary-General of the Commonwealth in the 1960s. He's a good writer, and every one of the members of the EPG took a very active part in working with him on the text. There were intensive debates. Our meetings took place, as I've said, in London, but also we had one meeting in Malaysia at the invitation of Tun Abdullah Badawi. And we came up with a lot of recommendations. We don't have the time now to go through all of them. Many of them, most of them, have been adopted in one way or the other by the subsequent CHOGM meetings. On matters such as border crossing. Why should it be that when we arrive at Heathrow Airport or any other airport in the United Kingdom, we are sent off to the other? Why shouldn't we have a special lane with a little bit of priority for Commonwealth of Nations. And that is something. A lot of the members of the EPG wobbled on that. I'm letting you into a little secret here, but I held firm. I said we should have our own special lane, and even if we only get 2 minutes speed, then that is worth doing, because the one time when your nationality status as a citizen of the Commonwealth is important is when you get to a border. And by the way, it should also operate in Australia and in India and in South Africa and in Kenya. And when you go to Africa, you know, they're very generous to African countries, but there should be a Commonwealth lane. And the EPG came up with this recommendation, and we had some real support within the UK government, and I haven't yet written that off. It's still with the officials. The Sir Humphreys of this world are still in place and still looking at that one, but we should never give up. And we should ask the Secretary-General to ask what's happened to border control. We also looked at climate change, a very real issue for the small island states. 53 member countries, but 53 includes a lot of little islands, both in the Pacific and in the Caribbean and in the Indian Ocean, with the Maldives threatened by going under the water. And therefore, these are very important issues. We don't have time now to go through all of these recommendations, but I commend them to you if you get the EPG report online. But there were 4 big recommendations. The first of these was for a charter of the Commonwealth. Now, that sprang at our very first meeting. I can remember it very vividly. We met in the residence of the Secretary-General, Kamala Sharma, a charming, civilised, well-read and a very hospitable host he was. And I remember it was Tun Abdullah Badawi who said we should have a charter. And he was thinking of a charter like the United Nations Charter, an organisational charter, a charter which would talk about the Secretariat, the Secretary-General and the structures. In the end, the EPG came to the view that getting that into place would take more time than we had. And therefore, we began to talk about a different kind of charter. At the end of every CHOGM meeting, there is a grand declaration. If you're in any doubt, they're all there online, and they get longer and longer, and grandioser and grandioser. And they are very long and a bit long-winded. And so we decided what we should try to do is get the essence of that in a Commonwealth Charter of Values, because no one reads. I'll defy anybody in this room who's not an official to put up their hand and say they've read every one of those charters of every CHOGM meeting. It's just not interesting enough. People won't do it. But if we could get something like the UDHR, something brief that says what on earth we're still on about. We don't have to be members of the Commonwealth, but we still want to be members of the Commonwealth. Well, why? What are our values? And so we decided we would accept the idea of a Commonwealth Charter of Values. We didn't think we had enough time to prepare the Charter. Interestingly, that's exactly what happened in the United Nations. The Charter of the United Nations in 1945 was supposed to have the Universal Declaration within it, but they ran out of time. They had to get the Charter of the United Nations adopted within a matter of weeks after the end of the war, and therefore they postponed the Universal Declaration to 1948. Well, much the same happened to us. We didn't have time to prepare it. And so we said there should be this value thing. It could draw on the Singapore Declaration and all the other declarations, and it should be available for schools throughout the Commonwealth to tell people, young people, what the Commonwealth stands for. And when I was in the plane going home to Australia, it's a very long journey. It's at least 24 hours, generally more when you add in stopovers and other delays. But Qantas Airlines, out of its generosity, gave me a pile of paper napkins. They're ever generous in Qantas. And so I thought, what would a charter contain? This is what happens if you are a neurotic judge, you see, sitting in the Qantas jet and you've got nothing to do for 24 hours. And so I began just to jot down what the earlier declarations had said and to write it down. And I thought, will I put in there sexual orientation? And I thought, no, that might be a bit risky. That might sink the ship. And so I left it out, but I left in the words that appear in the Universal Declaration of Human Rights. No discrimination on the grounds of gender, race, skin colour, ethnicity, so and so and so and so, or other grounds. That's what it has in the Universal Declaration of Human Rights. I thought if that's good enough for the United Nations system, that's the way, and allow countries and people to get to a greater understanding on this issue. And so there I was, writing this down. All of these precious serviettes are in the possession of the archives of the Commonwealth Secretariat. One day somebody will put them on a stand and say, this is how it all started. Anyway, so impressed were the members of the EPG when it was typed up that they thought, well, we're not going to adopt it, but we're going to append it to our report so it gives a start. V.I. Lenin taught the enemy to getting any action in any organisation is the blank page. And V.I. Lenin had a lot of experience and in changing a lot of things. So the page was filled and it was put to the members. They attached it to the EPG report. They weren't endorsing it and saying that's it, but they were saying it's a good start. And so there it was. And that was the charter. The second step, important step, was to enhance the role of the CMAG. The CMAG is the Commonwealth Ministers' Action Group. This is a small body to operate the Commonwealth between CHOGM meetings. And it's a body which has not been very effective, but amongst other things, the EPG said the CMAG should have the responsibility of considering any prolonged and serious abuses of human rights and should consider whether such matters akin to the actions of South Africa and Rhodesia, but not only on race, should authorise CMAG between CHOGM meetings to take steps to suspend countries from Commonwealth membership. The third suggestion was for a commissioner. We made a big mistake at this point. We called the Commissioner for Democracy, the Rule of Law and Human Rights. The reason for doing that was that they were the tasks we had in mind for the Commissioner, but it was such a long-winded title that it really wasn't a good strategic move. However, that's what the EPG called the Commissioner. We considered that the Commissioner was needed so that the Charter would not be just another document like the documents that come out of the end of every CHOGM meeting. We thought that it was important that the Charter should be given some more effectiveness and that there should be an office holder who should assist the Secretariat to give more effectiveness to the values of the Commonwealth. We had in mind that in 2009, before we started, the Royal Commonwealth Society had conducted a big poll. It was conducted in many Commonwealth countries, and the result was that the poll showed that in our countries, people knew about the Commonwealth Games, but they had no idea what the Commonwealth means. They had no idea what the Commonwealth does. They had no idea what the Commonwealth stands for. They thought, significant numbers, thought that Barack Obama was the head of the Commonwealth. And so we considered that we had to give more energy to the Commonwealth, and that a person such as the Commissioner would be the way to go. We had in mind the organisational reality. If you are the Secretary-General, you are dealing all the time with heads of government. And it's often, therefore, difficult for you to tell them, well, this is actually not in line with Commonwealth values. It can be done. Sometimes it should be done. But it's awkward. Functionally, it's awkward. Organisationally, it's awkward. And so what was necessary, we thought, taking the clue from the United Nations model of the High Commissioner for Human Rights, is to have someone who is a kind of burr under the saddle. And the Secretary-General could say, but the Commissioner is saying we've got to do this, or the Commissioner is suggesting we look at that. Look at those 3 points that were made yesterday in our session, in our plenary session, about the actions that have been taking place in the Commonwealth at the moment. The actions of the Boko Haram group in Nigeria, the actions of the violent people in Kenya, the actions of violent people in South Africa were mentioned yesterday in our session. These are human rights affronts, and we need somebody as a Commissioner whose focus is on human rights. And so that was one of the most important things that should be done. Just before we finalised our report, the head of the Human Rights Unit of the Commonwealth Secretariat resigned. Purna Sen, Dr. Purna Sen is her name. And she resigned because she said that she wasn't making any headway. The Commonwealth wasn't really sincere about human rights. She said that the Secretary-General had given instructions to all members of the staff not to speak ever on human rights matters, and that issues that should be raised by the Commonwealth were not being raised. And that's why we thought there should be a Commissioner. The Secretary-General was present throughout our meetings, and he never expressed any anxiety or concern, least of all opposition, to the idea of the Commissioner. And so it was that we all got together in Perth, or those of us who could get there. I think there were 6 of the 10 in Perth. Tun Abdullah Badawi was there, I was there, and the matter at the moment when the CHOGM was talking about the EPG report, we were allowed to come into the room. Most of the time we were not in the room. It was just the CHOGM heads of government and their officials. But we were allowed in, so we were sitting there. And at a certain point, one of the heads of government, I'm not sure who it was, asked a question. I think it might have been what we call in parliamentary terms, I'm sure it's so in all of our countries, a Dorothy Dixer. He asked a question of the Secretary-General. Secretary-General, what do you think about this idea of a Commissioner? And at that point, to the great shock of the members of the EPG, the Secretary-General said, I don't see why we need it. I think this can be done by the Secretary-General. And we were really stunned by that, but we got something of the flavour of what was happening when we then went downstairs to our press conference. We were ushered out of the meeting. We were sent downstairs to the press conference, and copies of our report were not available. we were told the report is still under embargo. It is still being considered by their excellencies, the Commonwealth heads of government, and we can't release the report and you can't speak to the detail of the report. Because of my training had been as a judge, I was inclined to let that pass, but one of our number was not. He said, "This is ridiculous. This is not a report that belongs to the governments or to the Secretary-General or the Secretariat. It belongs to the people of the Commonwealth. We have laboured on this. I now deliver my copy of the report." Bang, they threw it down. Needless to say, this was a former politician. And so the report got out. But a very interesting thing happened when the Secretary-General said, "I don't see a need for it." One solitary voice in the heads of government raised his hand, and it was Mohamed Nasheed, the newly elected president of Maldives. Nasheed had been in prison for 13 years before he was elected president of Maldives. Nasheed was an opponent of the Gayoom government, which was a very autocratic government of Maldives. And Nasheed said, "Well, Chairman, I think there's a need for it. I think there's a need for a commissioner. In the 13 years I was sitting in my prison cell in Maldives, I wrote many letters to the Commonwealth. I never received a single reply. I wrote letters to successive Secretaries-General, none of them answered. Maybe if there had been a commissioner, even," and he looked down, "a commissioner for democracy, the rule of law and human rights, maybe, just maybe, I would have received a reply." There was a long silence after that. The idea of a commissioner wasn't dispatched at that moment, but it was sent off to that graveyard of brave ideas, the officials of the heads of government, and the net result was that the idea of the commissioner was not accepted. And so we have another hortatory document, but no machinery to give it effect. And the final important of the four big important things was a section of the report on HIV/AIDS. And that section of the report, the whole report was unanimous, and it was written with the full participation of all members, drew attention to some statistics and graphs which were reproduced from work that was then being done by the United Nations Development Programme Global Commission on HIV and the Law. And they showed that in the Commonwealth Caribbean, HIV is a big problem. In the world, HIV in the Commonwealth countries is a big problem. Commonwealth countries have twice the levels of non-Commonwealth countries. And so the reason for this was questioned. Why should this be so? Why should HIV, just a virus, a disease, why should that be attacking Commonwealth countries? This is a Commonwealth problem. We had to deal with it. And we took the key from the UNDP suggestions that if you criminalise a portion of the population that is at risk of HIV, and that includes sex workers, it includes injecting drug users, and it includes men who have sex with men, gay men. If you criminalise them, you make it much harder to get the messages of self-protection into their minds and into their actions. And so that was the recommendation which the EPG meant and said. And the net result of that was that that was sent off to officials, and whilst it was adopted in a general sense, the ominous point was made, we will decide what laws are discriminatory and we will take such actions as in our separate countries we think is appropriate. And so that was the result of the Eminent Persons Group on the Future of the Commonwealth. So the question, in a sense, before this meeting of the Commonwealth Law Association is, was the Secretary-General right? Forget about the way it happened. Was he right to say that functionally the Secretary-General can do the job of monitoring human rights? And in my written paper, which will be available to you, which I'm not reading but which is there, I set out 3 parables. The first is the case of Sri Lanka. In January 2013, the Rajapaksa government of Sri Lanka sacked the Chief Justice of Sri Lanka, Shirani Bandaranaike. She went to court and said, this is being done contrary to the constitution of Sri Lanka. I am entitled, under the constitution and just by natural justice, to due process. I have to know what I'm being charged with. The Chief Justiceship is an important office of state and you should not remove a Chief Justice without due process. Her appeal to the courts was upheld by the High Court and by an intermediate interlocutory decision of the Supreme Court. But the President Rajapaksa, determined to be rid of her, and he went ahead. Cases were quoted from England concerning the supremacy of Parliament. But Sri Lanka is a country with a written constitution. It's a country with a separation of powers in the written constitution. It gives the final word on constitutional questions to the courts. This is something that the Supreme Court of the United States in the earliest days of the American Republic said, you have to have an umpire. It can't be the politicians because they are interested. It has to be the courts. And so the courts in Sri Lanka were doing that. The Secretary-General immediately called for 2 expert reports on the matter. He sought an expert report from Justice Pius Langer. Pius Langer was the Chief Justice of South Africa, a beautiful man. I remember him well, a man of the greatest integrity, decency, and legal brilliance. He was the first black Chief Justice of South Africa. And he wrote a report saying what President Rajapaksa is doing is unconstitutional. The person whom he has appointed as the Chief Justice has no right to be in that office because the Chief Justice in office has not been constitutionally removed. The Secretary-General also sought the advice of Sir Geoffrey Jowl, QC. Sir Geoffrey Jowl is a most distinguished lawyer in London. He's a lawyer of South African derivation, but a man who was fearlessly opposed to the apartheid regime and had to leave South Africa because of his opposition to that regime. He said this is very serious breach of the constitution of Sri Lanka. A meeting of CMAG was convened for March 2013, that's 2 months after the removal, purported removal, and the Secretary-General did not make the 2 advices, the content of which was only later discovered, available to the CMAG, and the CMAG had to consider the matter and apparently considered it for some little time without the benefit of the advice of the 2 constitutional experts. The reason for not making the reports available was said to be that these were reports to the Secretary-General and not. And if every legal advice given to the Secretary-General had to be spread around to all and sundry, the Secretary-General's entitlement to get independent advice would be undermined. The net result was that no steps were taken to consider, as would otherwise perhaps have been considered, whether the Colombo meeting of the Commonwealth heads of government should go ahead shortly thereafter. And the net result of this was that 3 countries of the Commonwealth, Canada, India, Prime Minister Singh, and Mauritius, did not attend the Commonwealth conference with their head of government. They sent ministers. There was great deference in the CMAG when they later discovered what had been advised. The Secretary General said he wanted to go ahead with his good offices. So what was achieved? Nothing was achieved. The Secretary General's response was to offer a compendium of Commonwealth practices on the removal of justices from high courts. And he offered Sri Lanka technical assistance so that presumably it could act technically correctly in any future removals of a Chief Justice or Justice, but no response to the removal of the then current Chief Justice. The meeting of CHOGM took place in Colombo. President Rajapaksa was in the chair. It was a very important meeting from his point of view. Subsequently, as we know, in January of 2015, he was unexpectedly voted out of office. No thanks to the Commonwealth, no thanks to the Secretary General, and his refusal in office to have assistance from the United Nations or other bodies remained a blot on his administration. So that is the case of Sri Lanka. Interestingly, on the night of the election, there were only a small number of people with President Rajapaksa at 2 a.m. in the President's palace, and one of them was the lawyer who had been appointed to be the Chief Justice of Sri Lanka, who was there with him, possibly considering what interim decree might be adopted to keep President Rajapaksa in office, but in the end that didn't happen, and President Rajapaksa retired and is no longer in public office. The second parable is the Maldives. You remember what I told you about Mohammed Nasheed. After 13 years, he was able to stand for an election, and he succeeded and was elected in 2009. He was the one who spoke up in Perth in 2011, but in 2012 a coup d'etat took place, which was said to have been organised by his predecessor, Gayoom, the man who had had a very autocratic regime in Maldives. A new election was held. Nasheed won the highest votes, but eventually he was declared not to have been the winner in a rerun. And in 2013, in the words of Jose Ramos Horta, the Nobel laureate for peace, the family dictatorship of the Gayoom dynasty was restored in the Maldives. The Prime Minister is the brother of Mr. Gayoom. The Foreign Minister is the daughter. In 2015, the Commonwealth had to consider what it would do, because unfortunately President Nasheed has been arrested, and as we meet here in comfort in Glasgow, he is in a cell again in Maldives, in a cell whose toilet has already been condemned by United Nations investigators who had seen it before. No doubt he's familiar with the cell, and I don't think he would be writing to the Secretary General, because he knows that letters he sends to the Secretary General will not be answered. The response of the Secretary-General to these events is contained in a half-page press release which was issued, and I leave it to you to consider whether this is an adequate response. He said, "The Commonwealth has taken note of the verdict released by the Criminal Court of Maldives on the 13th of March 2015. The verdict is a significant one, and at this stage is part of an ongoing judicial process which the Commonwealth will continue to follow closely. We urge restraint by all concerned in reacting to the verdict. Differences of view in Commonwealth societies are resolved in a lasting way through peaceful means, including dialogue and in accordance with democratic principles and the rule of law." End of quote. When Jose Ramos Horta heard of that statement, a man of pious manner, was alleged to have said an expletive which begins with the word bull. I won't deface this meeting by giving you the full expression, but he was not impressed. The idea that the proper response to human rights, including someone who has been sitting at the table of the CHOGM just 3 years earlier, is to express concern, encourage peaceful consideration. These are the responses of a diplomat. They are not the responses of a body which says it is a values body, a body concerned with values. The final matter is a matter on which we had a discussion in the preceding session concerning HIV/AIDS and the removal of the laws against LGBT people, gay people in Commonwealth countries. I indicate now, as I did in the earlier session, I am myself homosexual. I don't intrude that personal note in order to gain some traction in the argument, and I don't introduce it to embarrass anybody. It's just a fact, and I think candour requires that I should reveal it so that you know where I'm coming from. But even if I were not gay, I think I would be concerned about the third paradox. The EPG, made up of people of different backgrounds, different religions, unanimously said we've got a big problem on our hands with HIV. Whatever you think about gays and others, we've got to do something about it, and it's got to do it quickly. Well, what has happened? Tiny little rays of light in Botswana, an organisation for law reform on this subject, has been permitted by the courts. In Malaysia, on the 14th of November, an important decision was reached in favour of transgender people. Similarly, in Kenya last year. In Australia, a decision was reached on intersex people, people of indeterminate gender. In Bermuda, a decision was made of the courts upholding a right of people under the Constitution of Bermuda to adopt a child. In Fiji, the 2013 post-coup constitution affirmed no discrimination on grounds of sexual orientation. In the Cook Islands, they've amended their law, but it's not yet in force. But there have been many big disappointments. The biggest disappointment I would single out is in India, where a decision of the Delhi High Court upholding the principle of equality of treatment was overturned by the decision of a two-judge bench of the Supreme Court of India, reinstating criminalisation of gay people in India. That is now under an application for a curative petition, but curative petitions are often asked for and rarely granted. In Uganda, the Anti-Homosexuality Act was upset, but not on the merits, but simply because a majority had not been properly established in the Parliament at the time it was adopted. And now a new law, the Prohibition of Unnatural Practices Bill, is before the Parliament of Uganda. In Nigeria, there are likewise prohibitions in law in the states, some of the states, on the promotion of homosexuality. And it's such that if somebody went there with the EPG report, they might be found guilty of promoting law reform that favours homosexuals. Freedom of expression is important for the advance of knowledge and ideas. The Singapore decision of the Court of Appeal refused to disturb Section 377A of the Singapore Code. In two African countries, Rwanda and Mozambique, which are members of the Commonwealth but which were not British colonies, attempts were made to instill in their constitution, in their penal law, a law against homosexuals. In Rwanda, the president said, no, we're not going to have that. Our law never had those laws. Our law was Belgian law. Our law was derived from French law. We've never had that since 1793, and we're not going to introduce it now. And so that was defeated in Rwanda. Mozambique, the law was changed to include a crime, and that law has just been repealed in Mozambique. It doesn't fit naturally to countries of the non-British background. And what has the Commonwealth and the Secretariat and the Secretary-General done through all this? Silence. Silence has been the keystone of the response of the Secretariat. When Gambia, a country, decided that it would walk out of the Commonwealth, it did so with its president saying that homosexuals are satanic, they are an evil force, and that cases of aggravated homosexuality will be treated with very great seriousness. The Secretary-General said, we look for the return of Gambia to the Commonwealth. He didn't say, we look for a return of Gambia to the Commonwealth when it gets its laws in accordance with fundamental human rights. What a contrast there is here, ladies and gentlemen, fellow citizens of the Commonwealth. What a contrast with the Secretary-General of the United Nations, Ban Ki-moon. Here, this man from Seoul in the Republic of Korea, nothing to do with the Commonwealth, repeatedly says that the laws against homosexuals are irrational, they are unjust, they are contrary to human rights, and they make no sense from a public health point of view. Our Secretary-General is silent. And so we come to the end. Later this year in Malta, there will be the election of a new Secretary-General. I have no animosity to Kamala Sharma. He is a charming man. He is an able man. He is a highly intelligent man. He is an extremely well-read man. He sat with us at our table, and he didn't tell us that he was going to torpedo the Commissioner, but he did. With all great respect, he was not a Secretary-General for the current age. And unless we in the Commonwealth can get our machinery into a way that we can go back to a time which I remember when we were proud of the Commonwealth, when the Commonwealth stood up in South Africa and in Rhodesia and stood up against the coup makers and stood up in those cases, it must stand up today for values, for human rights, for the dignity of every Commonwealth citizen, man and woman, young and old, black, white, and every colour, professional and garbage collector, straight and gay. That is our Commonwealth, and the human rights of all is important. And I hope and pray that the next Secretary-General of the Commonwealth will see that mission and will ensure that the mission is fulfilled. Till the war drum throbbed no longer and the battle flags were furled, in the Parliament of Man, the Federation of the world, where the common sense of most shall hold a fretful realm in awe, and the kindly earth shall slumber, lapped in universal law.
Thank you very much. Thank you very much, Your Honour. We've got a little time, a couple of minutes, if anybody, maybe one or two people, either want to ask a question or make a comment for His Honour to respond to. Anybody? Or are you happy with that? Yes, sir. You'd like to come forward to the microphone here, say who you are, where you're from.
My name is Tolani. I practice in Nigeria. The Commonwealth is common so long as we respect our individual cultural orientation. A situation where people from other countries will come to Nigeria to come and tell us that this is the way you must do things, I don't think it's all right. Where we come from, it is satanic for you to even contemplate having a sexual relationship with a man. As a man, we do not believe that what applies in America should come and apply to Nigeria. Hence, when the laws were being made, in spite of the interest lobby and even the threat by so-called powerful people, the thing became very clear in the course of the public hearing that we as a nation and our citizens, majority, do not believe in your so-called civil partnership. Our human right is to the extent that we respect the cultures of the country where they reside, not to import wholesale the orientation of other countries to our country.
Well, thank you. Your Honour, that's a fundamental divide. If you have a quick comment in response.
Yes. First of all, I thank you for coming forward, and I respect you and I respect your country. When I was a young university student, I went with other Australian university students to Nigeria 2 years after independence in 1962. I can still sing the old anthem. Nigeria, we hail thee, our own true native land. Tribe and tongue may differ, in brotherhood we stand. Nigerians all and proud to serve our sovereign motherland.
And on that musical note...
May I just add something? In those words you heard, in brotherhood we stand. It also means in sisterhood too, brothers and sisters together. We stand together. We stand to learn from each other. And that's why the Commonwealth is so valuable. You stood up. I'm proud that you stood up and spoke. That is good. I stood up and I spoke from my heart and from my experience. This morning I spoke on the phone to my partner, Johan, in faraway Australia, of 46 years. Anyone who can tell me that I should not have had the loving support and kindness in good times and bad times, when I was right and when I was wrong, is not a kind person. But we can learn from each other, and that's why the Commonwealth is so precious. And I hope that what I have said to you will, in your quiet reflection, be a contribution to your thinking. You are hurt by me saying these things. Can I be truthful to you? I'm hurt by you as an African person who has suffered so many wrongs over centuries. not seeing that it's the same enemy. It's the enemy of those who want to make everybody exactly the same. Nature does not deliver that product. Nature makes us ourselves. I love and respect Nigeria and Africa and the Caribbean, Asia, and all the beauties of the Commonwealth. But we have to live together, we have to respect each other, we have to listen with our hearts as well as our minds, and we have to find a way to make the Commonwealth work.